that time under the plea agreement. If it's not, then it'll be set over on the subsequent trial docket. Anything else, Ms. Anderson?
No, Your Honor.
Anything else, Mr. Davis?
No, sir. Thank you.
All right, the defendant, Jerry Jones, is continued in the custody of the sheriff. We're in recess until Monday, September the 14th at 11:30.
We need Catherine Tilley.
Catherine Tilly.
Yes.
All right, we are on the record in calls number 241-1013-20 and 241-1055-20. These are both State versus Catherine Tilley, who is present before the court by Zoom with her attorney, Mr. Zach Davis. Ms. Anderson is present for the state. 241-1013-20 is an indictment. State versus Catherine Tilley, charging abandoning or endangering a child as alleged in the indictment. Calls number 241-1055-20, State versus Catherine Tilley. Again, present before the court with her attorney, State's counsel present. 241-1055-20, State versus Catherine Tilley. That is on an indictment charging the offense of manufacture or delivery of a controlled substance as alleged in the indictment. So we appear to be here today, obviously on Zoom, for announcements. Ms. Anderson.
Your Honor, I think Mr. Davis is going to ask for a continuance.
Okay, Mr. Davis.
Judge, that's correct. I talked with Mr. Shamus this morning. I think we may be able to get this case worked out. I didn't know if we could, but I think we may be able to get this case worked out. If we could put it on that September 14th date for the plea deadline day, I think that would be enough time. We'll be able to figure out whether or not this is going to be a plea or if we're just going to go ahead and set it on the trial docket.
All right, correct, Ms. Anderson?
Yes, Your Honor.
All right, September 14th, both these calls numbers, State versus Catherine Tilley, both calls numbers are reset by the court to September the 14th. September the 14th. I'll see if I can give you a time here in a minute.
1:30.
September the 14th at 1:30. Both cases will be called at that time by Zoom for announcements from the state and defense as to whether or not this is going to be a plea under plea agreements or whether or not it's going to be a trial. So as with those other cases, September the 14th would be the cutoff date on a plea agreement. Anything else, Ms. Anderson?
No, Your Honor.
Anything else, Mr. Davis?
No, Your Honor.
All right, defendants continued in custody. We are in recess on these cases.
What's your name, sir?
Ivan Bannock.
Okay. Should be a revocation.
All right, we're calling this case by Zooms. Calls number 2410668-18. State versus Ivan Bannock, B-A.
Are you still in your meeting?
State versus Ivan Bannock, B-A-N-E-K. He is present by Zoom with his attorney, Mr. Zach Davis. Ms. Anderson is present by Zoom representing the state. This is on the state's first submitted motion to adjudicate guilt, filed August the 18th, 2020. The court takes judicial notice of all the prior proceedings in the case. The court has the written plea admonishments and stipulations of evidence. The docket sheet reflects that on July the 5th, 2018, the case was called before the court. The defendant entered a plea of guilty, sentenced to 5 years deferred adjudicated probation, $180 restitution. Now, on August the 18th, 2020, the state has filed its first amended motion to adjudicate guilt, alleging violations of the defendant's deferred adjudicated probation. Mr. Bannock, raise your right hand. I'm going to have to swear you in. Do you solemnly swear the testimony you'll give before the court will be the truth, the whole truth, and nothing but the truth, and that all the documents which indicate you signed and then swore to the documents were sworn to by you freely, intelligently, knowingly, and voluntarily?
I do.
All right, Mr. Bannock, first of all, have you gone over the state's first amended motion to adjudicate guilt with your attorney, Mr. Zach Davis, so you understand the allegations being made in the state's first amended motion to adjudicate guilt, which allege violations of your deferred adjudicated probation?
Yes.
All right, now, in addition to the state's first amended motion to adjudicate guilt, and those paragraphs are up there which allege, those are the paragraphs alleging the state alleging violations of your deferred adjudicated probation is set out in those paragraphs. The court has before the court a document which is going up on the screen. It's a written plea, admonishments, and stipulations of evidence. Reflects obviously the original charge, state jail felony, less than a gram in the indictment, state jail felony. You having been placed on deferred adjudicated probation, if the court finds the allegations in the state's first amended motion to adjudicate guilt to be true, the court would grant that state's first amended motion to adjudicate guilt, go back and find you guilty of the offense of possession of a controlled substance, then you could receive up to the maximum 2 years in a state jail facility, fine of up to $10,000. Do you understand all that?
Yes.
The document up on the screen now that you're looking at is the written plea, admonishments, and stipulations of evidence, shows the original criminal charge, the maximum you can receive, which I just went over. That Mr. Zach Davis, your attorney, is also present. This document has a signature that I can easily read, Ivan S. Bannock, on the line above where it says defendant. It's also signed by your attorney. When you signed this document, Mr. Bannock, had you gone over it with Mr. Davis, your attorney, so he explained it to you where you understood what you were signing and what now you have signed and sworn to?
Yes.
And under this document, the written plea, admonishments, stipulations of evidence, there are 4 what we call admonishments, which are really just explanations, 1, 2, 3, and 4. Do you understand those explanations?
Yes.
Beyond their explanations, you'll see where it says that you, the defendant, and your attorney state that you fully understand and read the foregoing admonishments, as well as the allegations being made against you as set out in the state's first amended motion to adjudicate guilt. Is that correct, Mr. Bannon?
Yes.
Then the document says, understanding the admonishments as well as the allegations in the state's first amended motion to adjudicate guilt, which allege violations of your deferred adjudicated probation. You say under 1 that you are one of the same individual the court placed on deferred adjudicated probation in this cause number. Then under 2, you say that the allegations as set out in all the paragraphs of the state's first amended motion to adjudicate guilt, which allege violations of your deferred adjudicated probation, are true, and that you, with your attorney, you are entering pleas of true to all the allegations in all the paragraphs of the state's first amended motion to adjudicate guilt. Is that correct?
Yes.
You understand by stipulating and entering pleas of true to the allegations in the state's first amended motion to adjudicate guilt, allegations that you violated your deferred adjudicated probation. Obviously, the court would grant the state's first amended motion to adjudicate guilt because you've pled true to all the allegations. Then the court would go back, find you guilty of the offense of possession of a controlled substance, a state jail felony. Then Ms. Anderson will make a recommendation on time you would receive in a state jail facility, which I'm sure you and Mr. Davis have discussed, the court would follow her recommendation. Do you understand all that?
Yeah.
All right, the court having it, the written plea admonishes stipulations of evidence signed and sworn to by the defendant, signed by his attorneys. That's states 5, sworn to now by the defendant. You want to offer states 5, Ms. Anderson? Court admits into evidence states 5. Any objection, Mr. Davis?
No objection, Judge.
With no objection, states 5, the written plea admonishing stipulations of evidence is admitted into evidence, signed and sworn to by the defendant, signed by the defendant's attorney, wherein the defendant stipulates, admits under oath the allegations, all the allegations in the state's first amended motion to adjudicate, which allege violations of his deferred adjudicated probation in all paragraphs. The court finds the allegations in the state's first amended motion to adjudicate guilt, alleging violations of the deferred adjudicated probation to be true, having admitted into evidence states 5. The court grants the state's first amended motion to adjudicate guilt. The court finds the defendant guilty of the offense alleged against him by the state in its indictment in this cause number, a state jail felony possession of a controlled substance. You have a recommendation, Ms. Anderson?
Your Honor, the state recommends 15 months confinement in the state jail.
That's correct, Judge.
The court in this case, having received and accepted the defendant's pleas of true to the allegations in the state's first amended motion to adjudicate guilt, having admitted into evidence states 5, the written plea admonishing stipulations of evidence, the court finds the allegations in the state's first amended motion to adjudicate guilt to be true. The court grants the state's first amended motion to adjudicate guilt. The court does find the defendant guilty of the offense alleged in the indictment, possession of a controlled substance, a state jail felony, and the court, following the agreement, the recommendation of the state, assessed the sentence at 15 months in a state jail facility, assessed with credit for time served, restitution order, DPS for the lab fee. Any legal reason for formal sentencing, Mr. Davis?
No legal reason, Judge.
Finding none, the court formally pronounces the sentence. The court does find the defendant guilty of the offense of possession of a controlled substance. A state jail felony is alleged in the indictment. Follows the agreement. The recommendation of the state assesses the sentence at 15 months confinement in a state jail facility. Restitution order to the Department of Public Safety in the amount of $180 for the lab fee. The 15-month sentence assessed in a state jail facility is assessed with credit for time served. I have from you, Mr. Vanek, actually a waiver. This waiver that I have in front of me, it's a waiver of your right to file a motion for new trial. It's a waiver of your right to appeal. It's signed by you and Mr. Davis. Do you understand this document waives and gives up your right to appeal?
I do.
Okay, are you waiving your right to appeal freely, intelligently, knowingly, and voluntarily?
Yes.
The court receives and accepts a waiver of motion for new trial. The court receives and accepts the waiver of right to appeal, files it, filing the papers of the cause. Mr. Zach Davis has been your court attorney, court appointed attorney, Mr. Vanek. Are you satisfied with Mr. Davis' legal representation?
Yes.
All right, it'll be the order of the court. You will be continued in the custody of the sheriff until such time as you can be transported to a state jail facility to serve the 15-month sentence assessed by the court with credit for time served. Restitution order is part of the sentence to the Department of Public Safety in the amount of $180 for the lab fee analysis. Waiver of appeal is accepted. Anything else, Ms. Anderson?
No, Your Honor.
Anything else, Mr. Davis?
No, sir.
Defendants continued in custody until they can be transported to a state jail facility. Serve the sentence assessed by the court with credit for time served. Restitution order. We're in recess.
We need Mitchell Frazier, please.
All right, the court is calling calls number 241-0733-20, State versus Mitchell Frazier. Yes, sir. Before the court by Zoom. 241-0733-20 is an indictment charging the offense of possession of a controlled substance. Court's also calling calls number 241-1042-20 on an indictment charging interference with child custody. Mr. Frazier, just raise your right hand. I have to swear you in. Do you solemnly swear or affirm the testimony you'll give before the court in both calls numbers today will be the truth, the whole truth, and nothing but the truth, and all the documents signed and then sworn to by you now are being sworn to by you freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor.
All right, Mr. Frazier, we'll just take them by the numbers and start off with, well, I'll take them by the degree. Cause number 241-0733-20, State versus Mitchell Frazier. You understand the indictment charges you with possession of a controlled substance. That's a third-degree felony, carrying a sentencing range of not less than 2 nor more than 10 years in the Texas Department of Corrections Institutional Division. Fine may be assessed of up to $10,000. Do you understand that?
Yes, Your Honor.
Up on the front, up on the screen now is going to be your agreed punishment recommendation in this case. You'll see it signed by Heath Chambliss, Assistant Criminal District Attorney. It's signed by Mr. Zach Davis. And then there's a signature on the line above where it says defendant right there. It's signed Mitchell Frazier. But is that your signature, Mr. Frazier?
Yes, Your Honor.
All right, that signature is going to be on all the plea documents in both cases. So in this one, 241-0733, if you do enter a plea of guilty to the indictment charging you with a third-degree felony as alleged in the indictment, Ms. Anderson is going to recommend your sentence to the court at 4 years in the Texas Department of Corrections Institutional Division. That would be assessed with credit for time served. I'm sure there would be restitution order to the Department of Public Safety in the amount of $180 for the lab fee analysis. Is that your plea agreement, Mr. Frazier?
Yes, Your Honor.
Is that it, Mr. Davis?
It is, Joe.
That's your recommendation, Ms. Anderson?
I'm sorry, Your Honor.
That's okay. Is that your recommendation?
It is, Your Honor.
Over in calls number 241-1042-20, State versus Mitchell Frazier. This one's on an indictment charging interference with child custody. You understand on that one, Mr. Frazier, all the allegations and the charge in the indictment for interference with child custody?
Yes, Your Honor.
All right, and do you understand that's a state jail felony, carries a sentencing range of not less than 180 days nor more than 2 years in a state jail facility? If you do enter a plea of guilty to this indictment charging interference with child custody, State's counsel, Ms. Anderson, is going to recommend your sentence in that case on the state jail felony at 12 months in this Smith County Jail. I'm sorry, 12 months. There's actually on the plea paper that you see, it says 12 months in the Smith County Jail. That's going to be 12 months in a state jail facility, the line right below there. It's about half and half. But do you understand if you plead guilty, State's counsel is going to recommend in the plea agreement your sentence be assessed at 12 months in a state jail facility, which would be assessed with credit for time served. Do you understand that, Mr. Frazier?
Yes, Your Honor.
And then with both pleas having been taken in the same hearing, the 4 years in the Texas Department of Corrections Institutional Division with credit for time served, and the 12 months in a state jail facility with credit for time served, those would be ordered to run concurrent or at the same time because both pleas are being done in the same hearing. Do you understand that, Mr. Frazier?
I do, Your Honor.
All right, I'm going to identify the plea documents. I have these plea documents, just for the record, I have these plea documents in each cause number. Now, the plea documents vary. I've already been over the plea agreements, but obviously with different indictments in each cause number, the plea documents are different in certain respects. But I'm going to identify for the record the plea documents I have in each of these cases. Each plea document in each case, Mr. Frazier, has been signed by you, Mitchell Frazier, or signed and sworn to by you, Mr. Frazier, also signed by your attorney and the state's attorney. My question to you is, do you understand all the plea documents in each one of these cause numbers that you've signed or signed and sworn to?
I do, Your Honor.
All right. I'm going to go through and identify them. I have these plea documents in both cases that vary as far as obviously the indictment, the charge in the indictment, your plea agreements. But I've already been over the plea agreements. I have those in both cases. Each case, I have an acknowledgement of admonishments, 5 admonishments. Number 1 in those admonishments gives you what I've already told you, the full range of sentencing in each case. Again, all these are signed by you and Mr. Davis. In each case, I have a waiver of trial by jury, Mr. Frazier, which tells the court you understand you have a right to a jury trial. But in each case, you're waiving and giving up your right to a trial by jury, just asking the court to hear the case on your plea of guilty without a jury. Is that correct, Mr. Frazier?
Yes, Your Honor.
Then again, in each case, I've got a signed and sworn to waiver of confrontation with witnesses and an agreement to stipulate. Each case, Mr. Frazier, has a stipulation of evidence in it, states to, signed and sworn to by you now, signed by your attorney. Do you understand the stipulation of evidence in each cause number? That's a written judicial confession under oath by you in each cause number to the allegations and the charge in the indictment in each cause number. Do you understand that?
I do, Your Honor.
And I have the following documents in both cause numbers: agreements to stipulate testimony, forms signed by you and your attorney, waiving your right to appeal, waiving your right to have a pre-sentence investigation done. Then there's a trial court certification of your rights to appeal in each case that will show each case is a plea bargain case. You have no right of appeal. Also, each of these trial court certifications signed by you and your counsel will show that you have waived your right to appeal in each case. Do you understand that, Mr. Frazier?
Yes, Your Honor.
All right, the only other documents the court has is where you're certifying back to the court the advice you've received from Mr. Davis on your rights to appeal. Now, those are the plea documents that the court has in each cause number, and the court does take judicial notice of the plea documents in each cause number. Do you have any questions for the court about the meaning of any of these plea documents, Mr. Frazier?
I understand the documents. The only question I had was due to the fact that I had to go to the hospital with some heart issues. They wanted Smith County to pay for it, and I told them no, I would do it when I get out. I would like to see, I told myself at the court, the DA, if there's any way on the state jail felony, if I could possibly have that sentence. Zach was going to ask, and I may need to back up and let him do it, but I wanted to find out if there's a possibility instead of 12 months, serving 6 months on that because of my heart condition that I have current, and because I've already turned my life. I've already lost a house and 10 acres of land.
Judge, I don't mean to interrupt or interrupt,
Yes.
Mr. Frazier. We've already
Yes.
discussed this. The plea agreement is what it is, and that's what we presented to the court. As I've told him already, this is what the plea agreement will be if it's going to be a plea agreement. So,
Also, Mr. Frazier, I'm going to order the 4-year sentence in TDC for the 3rd-degree felony possession of controlled substance and the 12-month sentence on the state jail felony for interference with child custody to run concurrently at the same time.
Okay.
Obviously, your 4-year sentence over here in TDC, it'll be running, and the 12-month sentence will run along with it, and you'll get credit for time served on both of them. So based on what Mr. Davis has said and what the plea agreements are, as far as your request to me, I would not be able to grant that because the plea agreement before the court's 12 months. But what I am saying to you, they're both going to run at the same time. Your 4 years in TDC with credit, in all likelihood, will be a longer time there than your 12 months in a state jail facility. So you basically can't guarantee anything, but in all likelihood, when you complete the 4-year sentence in TDC, since they're running at the same time, you will have completed the 12-month sentence. This is with credit for time served in the state jail facility. Do you understand what I'm saying?
Yes, sir.
All right.
And Your Honor, I'm sorry, I do just want to say for the record that the state has no intention of lowering it. We're going to take the 12 months on the state jail offense today, or that, I mean, this is the day to do that.
Well, do you understand that, Mr. Frazier?
Yes, Your Honor, I do.
All right.
Thank
Are you ready to go ahead on your pleas and proceed? with the present recommendations from the state?
Yes, Your Honor.
All right, I'm gonna go through now. I've gone through the plea documents, I believe, identified all the plea documents. I'm gonna go through and ask you a series of questions now. The record will reflect all these questions that I'm asking you apply to your pleas in both cause number 2410733-20. That's the third degree felony possession of controlled substance, and over in cause number 2411042-20, interference with child custody. Again, your plea agreement on the third degree is 4 to do in TDC with credit. Your plea agreement on the interference with child custody is 12 months in a state jail facility. Both are running concurrent at the same time with credit for time served. Here's the questions I'm asking you for purposes of your pleas in both cause numbers. Do you understand all the allegations, the full range of sentencing, all your plea documents and the state's recommendations and your plea agreement in both cases?
Yes, Your Honor.
All right. Do you read, write, and understand English?
Yes, Your Honor.
Have you consumed any alcoholic beverage in the last 24 hours?
No, Your Honor.
All right. Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, Your Honor.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, Your Honor.
Do you understand everything you're doing in court today?
Yes, Your Honor.
Have you been over everything about the facts of your cases and what you're doing in court today with your attorney, Mr. Zach Davis?
Yes, Your Honor.
Is he competent, Mr. Davis?
Yes, sir.
Any else of incompetence, Ms. Anderson?
No, Your Honor.
Court notes State's counsel signed her consent to approve of the waiver of trial by jury. Court approves the waivers of trial by jury and all the other waivers in each case signed by the defendant, signed sworn to by the defendant, signed by his attorney. All right, you understand all the allegations, the charge in each indictment, your plea agreements, and all these other plea documents that you've signed. Is that correct, Mr. Frazier?
Yes, Your Honor.
All right, in cause number 2410733-20, what is your plea today to the indictment in that cause number, charging you with the offense of possession of a controlled substance, a third degree felony as alleged in the indictment? Like, what is your plea to the indictment, guilty or not guilty?
Guilty.
In cause number 2411042-20, what is your plea today to the indictment, charging you with a state jail felony interference with child custody?
Guilty.
Are you entering your pleas of guilty to the indictments in each cause number today because you are guilty and for no other reason?
Yes, Your Honor.
Has anyone threatened you in any way or promised you anything to get you to plead guilty?
No, Your Honor.
Are you entering your plea of guilty to the indictments in each cause number because you are guilty and for no other reason?
Yes, Your Honor.
All right. Are you entering your plea of guilty to each indictment today freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in each indictment?
Yes, Your
Are you entering your plea of guilty to either indictment today because you have any type delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No, Your Honor.
All right, the court does receive and accept your plea of guilty to the indictment in each cause number. Okay, Ms. Anderson.
Your Honor, in each cause number, we'd offer States 1, the plea packet with signed waivers and admonishments, States 2, the stipulation, a sworn and signed stipulation of evidence, and States 3, the discovery compliance documents. And Your Honor, if I may add one thing, on cause number 2411042-20, that is one of the cases that's the discovery was presented in the new form, which is text share. And so if Mr. Davis does not have an objection, we're going to supplement the discovery compliance documents and that cause number with a particularized list of the items that were made available to Mr. Davis on text share. That will go with the 3914 form in that case.
Any objection, Mr. Davis?
No, sir. Thank you.
All right, those, what, is it still on both cases, States Exhibits 1, 2, and 3?
It is, Your Honor, just on these text share cases, this will be with States 3, the discovery compliance documents.
And the record will show that The court, with no objection, Mr. Davis admits into evidence states exhibits 1, 2, and 3 in each cause number, finding the defendant's waiver of his rights, execution of all the other documents in both cause numbers were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's pleas of guilty to the indictments in each cause number today were entered by the defendant to the indictments in each cause number today freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty to the indictment in each cause number, and the court does find the defendant guilty of the offense alleged against him by the state in the indictment in each cause number. That is, the court does find the defendant guilty of the offense of possession of controlled substance as alleged in 2410733-20. Follows the plea agreement, assesses the sentence at 4 years in the Texas Department of Corrections Institutional Division with credit for time served. The court finds the defendant guilty of the offense of interference with child custody, state jail felony as alleged in indictment 2411042-20. Follows the plea agreement, assesses the sentence at 12 months confinement in a state jail felony. Any legal reason for formal sentencing, Mr. Davis?
No legal reason, Judge.
Finding none, the court formally pronounces the sentence of each cause number. Court having received and accepted the defendant's plea of guilty to the indictment in each cause number, finding the pleas of guilty to the indictments in each cause number were done freely, intelligently, knowingly, and voluntarily. The court in each cause number does find the defendant guilty of the offense alleged against him by the state in each cause number, and the court does assess the sentence following the plea agreement in each cause number, formally pronounces sentence at 4 years in the Texas Department of Corrections Institutional Division for a third-degree felony of possession of controlled substance in indictment 2410733-20. The court in cause number 241-1042-20 follows the plea agreement, formally pronouncing the sentence at 12 months in the state jail facility with credit for time served. Each sentence and each cause number ordered to run concurrent with the sentence in the other cause number with credit for time served. Restitution is ordered to the Department of Public Safety in the amount of $180 for the possession of controlled substance lab analysis in cause number 2410733-20. Mr. Frazier, as I've already gone over with you, you understand you've signed waivers of appeal, giving up your right to appeal in each cause number. Or are you presenting those waivers of appeal to the court now on each cause number?
Yes, Your Honor.
All right, the court receives and accepts the waivers of appeal. I may have asked you earlier, but to be sure, are you satisfied with the legal representation of your court-appointed attorney, Mr. Zach Davis?
Yes, Your Honor.
All right, it'll be the order of the court then, Mr. Frazier. You're content with custody of the sheriff and cause number 2410733-20 until you can be transported to the Texas Department of Corrections Institutional Division to serve the 4-year sentence set by the court with credit for time served, and you're content with custody of the sheriff until such time as you can be transported to a state jail facility to serve the 12-month sentence set by the court in a state jail facility for the offense charged in 2411042-20, interference with child custody. Waivers of appeal granted and received in both cause numbers, credit for time served. Granted, each sentence is to run concurrent at the same time with the other sentence. Since there's nothing further, we will be in recess and defendants continuing custody be transported to the Texas Department of Corrections Institutional Division. Anything else, Ms. Anderson?
Yes, Your Honor. Just for the record, we'd also like to just admit for sentencing purposes, states 4 in each cause number, an electronic copy of the written discovery.
No objection.
With no objection, the electronic copy of the written discovery, states 4, is admitted into evidence and made a part of the recommendation, made a part of the record in each cause number on the defense pleas of guilty. Thank you, Ms. Anderson.
That's all we have, Your Honor.
Anything else, Mr. Davis?
No, sir. Thank you.
We're in recess.
Murray Richards, please.
And Your Honor, I'm going to have an announcement for Mr. Richards.
Okay, thank you, Ms. Anderson. right, the court is calling calls number 241-1617-18, State versus Murray Dwayne Richards, who is present before the court, along with his attorney, Mr. Zach Davis, and Ms. Anderson representing the state, all present by Zoom for purposes of this hearing. The court has in this cause number 241-1617-18, the state's first amended motion to revoke community supervision filed August the 24th, 2020. The docket sheet in the case will reflect that back on March the 27th, 2019, the case was called. The defendant entered a plea of guilty to the offense alleged in the indictment. The court followed the plea agreement, assessed the sentence at 10 years deferred adjudicated probation. And then subsequently, as the court's already said, on August the 24th, 2020, the state filed its first amended motion to revoke community supervision. The court would have already entered on a violation report that the court received on May the 30th, 2019. The court received a violation from the probation department. The court would have at that time issued a no bond warrant of arrest for Murray Richards, who is now before the court. So what was your announcement today, Ms. Anderson?
Yes, Your Honor, thank you. Your Honor, Mr. Richards, as you mentioned, we have filed a motion to adjudicate guilt in this cause number. Several of the allegations in that motion contain allegations of new offenses. Mr. Richards was arrested on July the 21st. Two of the offenses he was arrested on are new felony charges. We do not yet have those cases in our office, but we plan to present those for indictment once they are received. We're asking the court just to reset this. I don't have a date in the future. It may be 45 or 60 days by the time we get the case, get an indictment, and get new cause numbers. But we'd ask that this revocation be set on the scheduling order with his new cases.
Well, of course, the first admitted motion to revoke community supervision, that's obvious. That, in other words, there was a no bond warrant, so the defendant is obviously incarcerated now on a no bond warrant of arrest, and the court has the first admitted motion to revoke community supervision before it with the allegations. The court, at the request of State's Counsel, will reset the case to September the 28th at 9:30 to apparently, based on what Ms. Anderson's told the court, to give the state an opportunity to present additional cases with allegations of violations of the penal code to a grand jury.
Thank you, Your Honor.
All right. Anything, Mr. Davis, defendant's going to be continued in custody. Do you have anything on that? Do you have anything?
No, Your Honor.
All right.
I'm sorry. I'm sorry.
I'm sorry.
There we go again. No, Your Honor. That was my understanding the whole time. That was my understanding.
That's what I was basically trying to ask you. All right, the
Yes,
court then, by agreement with State Counsel, Defense Counsel, for the reasons Ms. Anderson has made clear for the record, the defendant is continued in jail on no bond, and this first amended motion to revoke community supervision and cause number 241-1617-18 is set for hearing before the court on September the 28th at 9:30 a.m. Defendants continued in custody under no bond, and appears there's nothing further. Will be in recess until September the 28th at 9:30, when the court will take up this first admitted motion to revoke community supervision. We'll be in recess. Defendants continued in custody.
Matthew Robbins,
What tank are you on?
Note on that one.
You throw it away.
Okay. Time for a quick break. This is the last one.
this is a plea, and then I have one more reset. So we
Okay.
got two more. You need a break?
Just for a second.
Okay.
Counsel, I'm going to take just a quick recess for about 5 minutes. I'll be right back.
Yes, sir.
Yes, Your Honor.
That way we can get the defendant in and on. I'll be right back.
Yes, sir.
All right.
Is there a- Hello? Oh, okay, okay.
We're taking a 5-minute break.
Yes, ma'am. I can. Okay. Uh, These are that's the probation officer you have?
Yeah, that's gonna be yours, but
Okay,
he'll go over all of that with you.
okay.
All right, we are back on the record by Zoom. Cause number 241-1626-19. State versus Matthew Robbins, who's present before the court from jail on Zoom. Ms. Anderson's present representing the,
She'll be right back.
that's right. Mr. Davis is present representing the state.
I'm not having any luck getting anybody up.
Not having any luck with who?
I tried to call up there and I didn't.
No, it don't hurt. No hurt. No hurry. Doesn't make any difference. No hurry. 71st, just another absconder lined up. God, I didn't shut the elevator way we get off this. Can't ever tell when it's bringing broadcast. Do you know what percentage? Do you know
Your own. Just let it go.
We're on the record in calls number 241-1626-19. State versus Matthew Robbins. Indictment charging aggravated assault with a deadly weapon. Second-degree felony is alleged in the indictment. He's present before the court on Zoom along with his attorney, Mr. Zach Davis. Also, Ms. Anderson representing the state's present on Zoom. Mr. Robbins, raise your right hand. I have to swear you in on this plea. Do you solemnly swear the testimony you'll give before the court will be the truth, the whole truth, nothing but the truth, and all the documents which show they are sworn to by you, were in fact sworn to by you freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, Mr. Robbins. The indictment in this case charges you with aggravated assault with a deadly weapon, second-degree felony. State's counsel's present, your attorney's present, court's probation officer, Marcella, all present by Zoom. You, Mr. Davis, do you want to waive the reading form presentation of the indictment charging aggravated assault with a deadly weapon and second-degree felony?
Yes, Your Judge. His name's set forth correctly.
All right, now, Mr. Robbins, have you gone over the indictment closely with Mr. Zach Davis, where you do understand all the allegations and the charge in the indictment?
Uh,
Do you understand
Yes, sir.
the allegations against you in the indictment?
yes, sir.
All right. You understand that's the full range of sentencing on aggravated assault with deadly weapons, not less than 2 years nor more than 20 years in the Texas Department of Corrections Institutional Division, and a fine may be assessed of up to $10,000. You understand that?
Yes, sir.
The state is recommending on this plea agreement that your sentence be assessed by the court at 7 years deferred adjudicated probation. Is that your plea agreement?
Yes, sir.
Is that it, Ms. Anderson? Is that your recommendation?
It is, Your Honor.
Is that the plea agreement, Mr. Davis?
Yes, sir.
All right, now, Mr. Robbins, I have plea documents. The first one's up there for the indictment's up there right now, but your agreed punishment recommendations going up. It's signed Matthew Robbins, and the signature down at the bottom of this form, when it goes up a little bit further, you'll be able to see the signature of Matthew Robbins. That's on all the plea documents. Is that your signature?
Yes, sir.
Did you go over each one of these plea documents with Mr. Zach Davis, your attorney, so you understand all these plea documents that you've signed or signed and sworn to?
Yes, sir.
Did you go over the allegations and the charge in the indictment with Mr. Davis so you understand the allegations, the charge in the indictment, and the full range of sentencing?
Yes, sir.
All right, here are the plea documents I've got. I'll identify them for the record. You have a plea agreement, agreed punishment recommendation. State's recommended if you plead guilty to the indictment, that state's going to recommend 7 years deferred adjudicated probation. No restitution is indicated is due. Is that your plea agreement?
Yes, sir.
Is that
Yes,
it,
sir.
Is that it, Mr. Davis?
Yes,
All right, is that your recommendation, Ms. Anderson?
It is, Your Honor.
All right, in addition to the agreed punishment recommendation, I've got an acknowledgement of admonishments. This will be important to you, Mr. Robbins. Full range of sentencing on the second-degree felony, aggravated assault with a deadly weapon. And your aggravated assault with a deadly weapon alleges in the second paragraph that you used or exhibited a deadly weapon, a knife, that in the manner and means of its use or intended use was capable of causing death or serious bodily injury during the commission of immediate flight from said offense. If you do stipulate and enter a plea of guilty to that indictment, I'm going to follow the state's recommendation, place you on deferred adjudicated probation for a term of 7 years. But you do need to understand if there's any violations and the state files a motion to adjudicate your case, alleging you violated terms and conditions of your deferred adjudicated probation, the filing of the motion to adjudicate itself would trigger a no bond warrant for your arrest. Do you understand that?
Yes, sir.
Then a hearing would be held. You'd be incarcerated again on a no bond. The hearing would be held, and if the state's attorney proved to the court, not a jury, that you had in fact violated any terms or conditions of your deferred adjudicated probation, the court can grant the state's motion to adjudicate the case, and the court would go back, find you guilty of the offense of aggravated assault with a deadly weapon. And then because you were on this deferred probation, the court could go back, find you guilty of the offense charged in the indictment, and sentence you up to 20 years in the Texas Department of Corrections institutional division. In addition, today you're going to hear the court make an affirmative finding based on your stipulation of evidence that you used or exhibited a deadly weapon. Now that'll be in the judgment, an affirmative finding in the judgment. That means later, if you violate any term and condition of your deferred adjudicated probation and it's proven to the court can grant the state's motion to adjudicate, go back and find you guilty of this second degree felony. And then because there's already an affirmative finding of a deadly weapon in the record, whatever time the judge assessed, you do a minimum half time of that. Do you understand that?
Yes, sir.
All right, that'll cover the plea agreement. There's an acknowledgement of admonishments. There's a waiver of trial by jury. You understand you are waiving, giving up your right to trial by jury?
Yes, sir.
All right, in addition, there's a signed and sworn to now waiver of confrontation with witnesses from you, agreement to stipulate. That's the stipulation of evidence. The next document up, the stipulation of evidence signed and sworn to by you now, signed by your attorney. Do you understand that stipulation of evidence is a written judicial confession under oath by you to the
Yes, sir.
to the offense of aggravated assault with a deadly weapon?
Yes, sir.
Right, the stipulation of evidence on or about the 29th day of June 2019 and adhere to the presentment of this indictment, the county of Smith, the state of Texas, you, Matthew Robbins, did that in there intentionally and knowingly threatened Michael Horner with imminent bodily injury by stabbing and slashing at Michael Horner, and did then in there use or exhibit a deadly weapon, namely a knife, during the commission of the assault. Just for purposes of the plea, Ms. Anderson, the way I read that language, Basically, he used or exhibited a deadly weapon. He's admitting that a knife in his stipulation of evidence. I'd read the language by stabbing and slashing at Michael Horner. That would mean to the court that the defendant did not actually stab or slash Matthew, did not stab or slash the victim. He attempted to. It's clearly the offense of aggravated assault, but he didn't actually cause injuries to the victim. Am I understanding that?
That's correct. He made stabbing motions and slashing motions. Yes,
Good.
Your Honor.
I figured that with your recommendation being 7 deferred. All right, you understand that stipulation of evidence, a written judicial confession under oath by you, Mr. Robbins, to the
Yes, sir.
allegations. All right, there's an agreement to stipulate testimony form for a waiver of appeal, request for waiver of the pre-sentence, which the court's approving. Trial court certification of your rights to appeal, certification from you back to the court on advice you've received from Mr. Davis on your rights to appeal. Now, you've signed or sworn to all these plea documents. Do you understand all these plea documents?
Yes, sir.
All right. And I'm going to go through and ask you some questions now. If I ask you some questions you do not understand, this is for purposes of your plea. Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything you're doing in court today, as well as all these plea documents you signed with your attorney, Mr. Zach Davis?
Yes, sir.
And you've gone over the facts of your case with Mr. Zach Davis, is that correct?
Yes, sir.
Is he competent, Mr. Davis?
Yes, sir.
Any evidence of incompetence, Ms. Anderson?
No, Your Honor.
Court notes State's counsel signed her consent to approve the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers of the case signed by the defendant, signed or sworn to by the defendant, signed by his attorney and State's attorney. All right, you understand all the allegations, the charge in the indictment for aggravated assault with a deadly weapon, Mr. Robbins, is that correct?
Yes, sir.
And you understand all these plea documents that you signed and sworn to, including that State's to the signed and sworn to stipulation of evidence, is that correct?
Yes, sir.
Do you have any questions for me about anything?
No, sir.
All right, in cause number 241-1626-19, what is your plea today to the indictment in this cause number charging you with aggravated assault with a deadly weapon, second degree felony as alleged in the indictment?
Okay. Yes, sir.
Okay, what's your plea?
Oh, it's guilty.
All right, are you in on your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way, promise you anything, or coerce you, make you plead guilty?
No, sir.
Are you entering your plea of guilty to the indictment today freely, intelligently, knowingly, and voluntarily?
Yes, sir.
No one's threatened you in any way or promised you anything to plead guilty, is that correct?
No, sir. Yeah, yes, sir.
Okay, in other words, no one's threatened you, promised you anything, or coerced you in any way to plead guilty, is that correct?
Yes, sir. You're
All
correct.
right, the court does receive and accept your plea of guilty to the indictment. The court finds it was entered to the indictment freely, intelligently, knowingly, and voluntarily. And your plea of guilty was entered to the indictment because you committed the offense charged in the indictment. Is that correct, Mr. Robbins?
Yes, sir.
All right, you don't have any type of delusion in your mind or some type of unrealistic hope of pardon, parole, or leniency, do you?
No, sir.
All right, the court does receive and accept your plea of guilty. What do you have, Ms. Anderson?
Your Honor, we offer States 1, the plea packet with signed waivers and admonishments, States 2, the sworn and signed stipulation of evidence, as well as States 3, the discovery compliance documents.
No objection.
With no objection, States 1, all the plea papers, States 2, cited sworn to stipulation of evidence, States 3, discovery compliance are all admitted into evidence with no objection. The court in the cause number having received and accepted the defendant's plea of guilty to the offense alleged in the indictment, aggravated assault with a deadly weapon, second degree felony, finding the plea of guilty was entered freely, intelligently, knowingly, and voluntarily, and finding the evidence in the record on the defendant's plea of guilty to the offense alleged in the indictment is fully sufficient to support the defendant's plea of guilty to the indictment. However, the court does at this time withhold a finding of guilt as to the defendant. Will move to sentencing, Ms. Anderson.
Your Honor, we'd offer States 4 an electronic copy of the written discovery in this case.
No objection.
With no objection, Stage 4 electronic copy of the discovery in the case submitted into evidence without objection. The court in this case, having received and accepted the defendant's plea of guilty, finding it was entered freely, intelligently, knowingly, and voluntarily, finding the evidence in the record is fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment, the court does withhold a finding of guilt as to the defendant. Follows the plea agreement, the recommendation of the state assessing the sentence in the case at 7 years, deferred adjudicated probation, no fines assessed, court costs are ordered paid, no restitution is indicated as due, any legal reason to more formal sentencing. Mr. Davis.
No, sir.
Finding none, the court formally pronounces the sentence. The court does find the evidence in the record fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment. However, the court does withhold a finding of guilt as to the defendant. Follows the plea agreement, the recommendation of the state and assessing the sentence in the case at 7 years, deferred adjudicated probation. No restitution is indicated as due. Sentence is formally pronounced at 7 years for adjudicated probation. Mr. Robbins, I have a waiver of your right to appeal. It gives up your right to appeal. A waiver of your right to file a motion for new trial. It gives up your right to file a motion for new trial. Both signed by you and Mr. Davis. Are you waiving your right to appeal freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, court receives a waiver of appeal, a waiver of right to file a motion for new trial. Under the judgment signed by the court today, Mr. Robbins, that judgment will reflect the court has sentenced you to 7 years deferred adjudicated probation. You can be on deferred adjudicated probation for that entire time, or you can make application for an early termination if you serve 3.5 years, the minimum half time, and have not violated any terms and conditions of deferred adjudicated probation. That would be up to the court to decide whether or not to grant that. The other side of the road is, need to be sure you understand now, while you're on this deferred adjudicated probation, if you violate any term and condition of your deferred adjudicated probation, your probation officer, who you're getting ready to meet, will immediately file a violation report with the court. That'll trigger a no bond warrant for your arrest. Hearing is held before the judge. If the court determines you violated any condition of your deferred adjudicated probation, the court can grant the motion to adjudicate your case. Legal word, meaning the judge goes back, finds you guilty of the offense of aggravated assault with a deadly weapon, and then the judge can sentence you up to 20 years in the Texas Department of Corrections Institutional Division, and there will already be in the judgment an affirmative finding that you used to exhibit a deadly weapon, a knife. Do you understand all that?
Yes, sir.
All right, now, the Marcella, the court's probation officer, is present. What does he need to do now, Marcella, in terms, what does he need to do when he books out?
Your Honor, he will report to ISP Officer Ofelia Ramirez September the 10th at 9 o'clock. And our office will also contact Mr. Matthew Robbins today if he's released today.
All right, Mr. Robbins, you will get, my understanding, you will be receiving on paper, a piece of paper that will have the name of your supervising probation officer, Ofelia Ramirez.
I believe that's in front of me.
Good deal. That's good. Looking at it, you'll see her name X'd, Ofelia Ramirez. She'll be your assigned probation officer. When you book out of jail, do you have a time on that sheet? I don't have it in front of me. Do you have a time on that sheet that shows you when to report to her?
It says September 10th, 2020 at 9 a.m.
All right, September the 20th.
And Your Honor, before we finish up, could I just put a couple things on the record about Mr. Robbins' conditions of probation?
Oh, sure you can.
Okay, thank you, Your Honor. First of all, Your Honor, the state would like to ask you to order a post-sentence investigation as part of his conditions of probation today. Because this is a second-degree felony with a deadly weapon on it, we would ask for that to be ordered.
The
Also,
court will grant that request by the state order a post-sentence investigation, Marcella, which will contain all the facts of the case. Also, Mr. Robbins, within that, you'll have about 70, and I apologize for interrupting you, Ms. Anderson.
no, Your Honor.
For the record, Mr. Robbins, you will have as one of those 70 or so terms and conditions of your probation that you cannot have any contact with the victim in this case, Michael Horner, no contact with him by cell phone or any type of electronic device, Twitter or all those others. Cannot have any contact with Michael Horner, and you cannot be anywhere within 500 feet of where Michael Horner is. There'll be no contact provision in the case.
And I'm sorry, Your Honor, I didn't get to that before you got to that. Mr. Horner has requested that he could have contact with the victim. Since this occurred, Mr. Horner is no longer married to the defendant's mother. They have gotten a divorce, but he has specifically requested, if the court would allow it, that he could have contact with Mr. Robbins if Mr. Robbins so desires to contact him.
If Mr. Horner files an affidavit with the probation department
All right.
stating under oath that he is requesting he be allowed to have contact with a defendant, then the court will approve that as a term and condition that there will not be a no contact provision, Marcella, if you receive an affidavit from Michael Horner.
Yes,
And I'll notify Mr. Horner of that. And then finally, Judge, I just also wanted to put on the record that the original plea offer in this case included a recommendation for safety because there were some concerns about substance abuse. But because Mr. Robbins has been incarcerated since last fall, in fact, we're approaching a year. I think he's been incarcerated since last September. He did not want to subject himself to another indefinite wait for safety. As you know, because of safety, because of COVID, SafeP is on a very backlogged waiting list. And so in exchange for that, the offer for deferred, we agreed to 2 years of intensive supervision, the beginnings, and also counseling as outpatient counseling. So he is, even though the original offer was for inpatient because that was not available, we did tweak the conditions of probation, and Mr. Davis and I came to an agreement for him to do outpatient instead.
You have all that, Marcella. The defendant, Mr. Robbins, is nodding his head yes, so he obviously understands that. Do you have it, Marcella?
Yes, Your Honor. On the conditions of probation, I did a substance abuse evaluation and outpatient counseling and also anger management classes, Your Honor.
All right, of course, you understand, Mr. Robbins, those are all going to be conditions of your deferred adjudicated probation along with all the others, which your probation officer will explain to you when you report to her on this date and time. Do you understand that?
Yes, sir.
And Mr. Robbins, the main reasons I've noticed over the years are reflected by what a judge in the 7th District Court told me a long time ago. The number one requirement in order to be a successful probationer, as you're getting ready to be, is you have to timely report to your probation officer. Probation will not work if you don't report. It'll result in a bond violation, a probation violation, and a warrant. But reporting is basically, well, it should be the linchpin, and I'm talking about personally reporting to your probation officer. That's the linchpin of if you don't report as ordered, there'll be a no bond warrant go out for your arrest, because there's no way a supervising probation officer can supervise you if you're not reporting. Are you with me on that?
Yes, sir.
All right, the waiver of appeal is accepted. You have that sheet of paper, correct, Mr. Robbins, in front of you that gives you Ophelia Ramirez's name and the date and time you're to report to her.
Sir.
What date's on your sheet?
It says September 10th, 2020 at 9 a.m.
All right, that's the date you have to personally be in her office. Does he need to make contact with her prior to that date, Marcella?
Yes, Your Honor, and we'll be making contact with him via phone today. We'll be checking the jail And once he gets released, Ophelia or one of our supervisors will make contact with him via phone today.
You understand all that, Mr. Robbins?
Yes, sir. Do y'all have does she have a number that they'll be reaching me at, or
Could you provide one right now?
903
Okay,
497
okay,
4385?
okay. 43. Thank you.
I
Yes,
think I
ma'am.
may have, Mr. Robbins, just for the record, I made that, ask you this, Mr. Zach Davis has been your court-appointed attorney. Are you satisfied with Mr. Zach Davis' representation down through today where he's worked out this deferred adjudicated probation for you?
Yes, sir.
All right, anything else, Ms. Anderson? I'm sorry, anything else, Ms. Anderson?
No, Your Honor. I'm sorry. I was muted again.
Mr. Davis, anything else?
No, sir.
All right, anything else, Marcella?
Yes, Your Honor. I did note in our pretrial file that he resides in Quitman County, but we request that he report to Smith County.
Okay, he'll be ordered to report to Smith County. What did you say, where does he live?
Quitman and Wood County?
Oh, that's no problem. That's a shorter drive than a lot of places down south in Smith County. He will be ordered to report personally to the probation department here in Smith County, to his probation officer, Hilly Ramirez. I'm not transferring his supervision up to Wood County. It's too short a drive. Anything else?
Nothing further, Your Honor.
All right.
Nothing further from the state.
We're in recess.
Tucker?
Monday, August 31st. What's today's date? August. All right, we're on the record. We're on the record in 3 calls numbers. State versus Antonio Tucker in calls number 2410127-19. Also calls number 2410472-20, State versus Antonio Tucker. Also calls number 2410473-20, State versus Antonio Tucker. He is before the court by Zoom with his attorney, Mr. Zach Davis. Ms. Anderson is present, just for the record, since there are 3 calls numbers. 2410473-20, that's an indictment charging impersonating a public servant. Calls number 2410472-20, that's an indictment charging burglary of a habitation with intent to commit another felony. And then calls number 2410127-19. That appears to be a case from the docket sheet where the defendant back on May the 1st, 2019, entered a plea of guilty. Defendant was entered a plea of guilty to possession of controlled substance. Defendant was sentenced to 2 years, probated for 5 years, state abandoned enhancement paragraph. So apparently the defendant was on deferred adjudicated probation, and then take it that if I look further in the file, I'd probably find a motion to adjudicate and a no bond warrant. Is that correct, Ms. Anderson?
Your Honor, it is correct. He does have the revocation pending plus these two new cases. And Your Honor, I believe that Mr. Shamness and Mr. Davis have reached an agreement, but there were some issues with the plea paperwork. Those had to be redrafted. And because of the restrictions with COVID and Zoom, the paperwork is just not ready today. And so we're going to ask that this be reset next week, just so that Mr. Davis has an opportunity to get the correct paperwork and get it to his client and review it with him.
Mr. Davis?
Judge, that's correct. I need to figure out, it's not, that paperwork is done now. So I'm gonna pick it up, deliver it to the jail. They'll get the low risk. I'll set up the Zoom. Anyway, my next court is Monday, August 31st. So if we can just set for them, we'll get the plea done.
Monday, August 31st?
Yes, sir. This
Yes,
coming
sir.
Monday.
Yes, sir, because the agreement's reached. It's just a matter of executing the paperwork.
All right, then Denise, Monday, August the 31st, at what time, Denise?
9:30.
Monday, August the 31st at 9:30, we'll be back on Zoom to resolve these cases apparently by pleas. Is that correct, Ms. Anderson?
That is correct, Your Honor.
Correct, Mr. Davis?
Yes, sir.
Defendant is Mr. Tucker's continued in custody. Will reconvene by Zoom on that date stated by the court to resolve the cases. Defendant is continued in custody. Anything further, Ms. Anderson?
No, Your Honor, and I believe that concludes our morning docket.
All right. Well, there goes Mr. Tucker. I guess we're all heading, well, not heading in his direction, but I guess we're all in recess. Anything else, Mr. Davis?
No, I hope not. Yes, sir. We're done.
I was going to say, that pretty well wraps it up. Looks like you.
I think that'll take care of
We're
it.
at an end.
Yeah.
Marcella,
Uh-huh.
thank you.
Thank you, Your Honor.
Yes,
Thank
ma'am.
you.
We're in recess.